Okay, I think as it's now 1 o'clock, if we could kick off, thank you, Daniela, for warning everyone. And I just wanted to firstly say thank you to you all for attending our talk today. As you can see, the topic is consent and capacity issues for children and young people. My name's Anita and I'm a partner at Hempsons, and I'm here with my colleague Flora Jago, who is an associate, and we're both within the advisory team, and we deal with these issues day in, day out. And with that, I move to our overview. So our focus today is going to be on the following 5 points. And you will have had some of them forewarned in the email to you, but essentially the first question, why is this important? Well, as will be self-evident to many of you, it's crucial that when we're treating children that we are clear on the basis on which we are seeking consent. It is also a very timely topic because consent and capacity in cases of children and young people has become an increasingly tested and contested subject in the courts over the last few years. Cases have examined it in a variety of contexts: confinement, refusal to life-sustaining treatment, and accepting medical treatment, amongst many others. And as I say, inevitably, we cannot cover it all. So we're going to focus today on where it started, which is essentially with Gillick, and on whether that's still relevant and whether it's still good law, and its limits. Where does parental consent fit into this framework, and what are its limits? What are considerations for specific treatment decisions, and our consideration of some common problem areas and the future of these sorts of cases. So moving then to the starting point, Gillick. I know many of you will have heard this case 1,000 times, so I don't propose to stay on this too long. But there was little in the way of precedent prior to Gillick. The case was brought by a mother, Mrs. Gillick, who at that time had children aged 13, 12, 10 and 5. And she was essentially bringing a test case, just without the crowdfunding or the internet at that stage. And her challenge was to the Department of Health and Social Care's guidance, allowing doctors to prescribe contraception to girls under 16 without parental agreement. At that time, it was hugely controversial, and after some ping pong between the courts, it found its way to the House of Lords. And what did it decide? Next slide, please, Daniela. Lord Fraser, who delivered the seminal judgment in the case, was dismissive of the idea that under 16s had no capacity to authorise treatment, calling it something verging on the absurd to suggest that they couldn't effectively consent to a more minor intervention. And now I think that would seem commonplace, but at the time it was revolutionary. But moving to what Gillick really means for you, next slide, please, Daniela. I've extracted the key points from Lord Fraser's decision there, and I think there are 3 key elements to the decision that you need to be aware of. Firstly, it's the sliding scale, which is that as a child's decision-making capability grows, the scope of parental control diminishes. And that's how the law from Gillick onwards tried to reflect this general, gradual process of increasing autonomy on the part of a child. Secondly, the key point was this is not going to be the same for all children. So the actual child's understanding intelligence was central to the analysis and central to when a parent's control diminishes. And the third key point was that the law had to, in his view, be responsive to changes within society and to social customs. In fact, since then, the fact that we no longer talk about parental control and instead talk about parental responsibility, it being a duty to safeguard the welfare of children, for example, rather than a right or an entitlement where parents can do what they like, is another reflection of the way in which the law has moved on in this area. But for you, in reality, the practical and fundamental point that Gillick decided was that where a child had Gillick competence and had been assessed to be competent, that made them legally competent to make their own treatment decisions. What it meant is that you don't have to require consent from a parent. You can rely on consent to that treatment from the child. And the other point it was making was this was, clearly going to be decision and time specific. The more complex the decision, the more intelligence and understanding a given child would require in order to make that decision. So that was the fundamental point that Gillick was teaching us. And then arising out of that then came the Fraser Guidelines. Daniela, next slide, please. The Fraser guidelines took the decision of Lord Fraser and put it in the context of contraception. And we've set out there the key points that you need to know. But the reason I've, brought this to your attention today is really to make a slightly different point, which is that competence to make decisions under the Fraser guidelines is not interchangeable with a general assessment of Gillick competence. The Fraser guidelines, as we've set out here, is solely about sexual health and making decisions in relation to contraception, rather than the wider considerations that Gillick and the wider way in which Gillick has been taken and interpreted going forward. So when we sometimes hear clinicians talk about, Fraser competence, Gillick competence, they can't be used interchangeably in that way. And sometimes, we run the risk of error by using it interchangeably in that way. So it's more just to remind us that the Fraser guidelines, which came out of the Gillick judgment, concern contraception, but they aren't interchangeable with the concept of Gillick in general. So now that I've told you probably things you already know, moving then to the situation as it was then after Gillick. Since the decision in 1985, which is now 40 years ago, there has been an evolution in the way that Gillick has been understood and how it's been applied. And for a long time, Gillick has been very broadly applied as a conceptual framework to assess the understanding and maturity of a child under 16, and has then been used to allow them to provide their own consent in law to a particular intervention. And certainly in the case of medical treatment per se, that the GMC guidance reflects this, and it's paragraphs 24 to 26. I'm sure many of you will have looked at this, but the key points that the guidance identifies is that where a child is aged 16 to 17, we're working within a Mental Capacity Act framework, and while the child is under 16, then we are looking at a Gillick competence assessment. And that again comes back to the maturity and ability to understand what is involved with that particular decision. And the way in which the GMC expresses it is it's only if a child is able to understand, retain, use and weigh the information that's relevant to their decision and communicate the decision to others that they can then give consent to a particular treatment or investigation. And that, for many of you, will echo the functional requirements of the Mental Capacity Act. And that is the approach that the GMC takes to the way in which Gillick needs to be approached in this context. It also reminds us, as Gillick did, that consent, maturity and understanding need to be considered on an individual basis and with regards to the complexity and importance of the decision to be made. So far, so good. But then we moved to what has increasingly become the recognised limits of Gillick, as it's applied in ever wider and wider contexts beyond the context in which the decision was originally made. And what has been happening over the last few years is there's been an increasing number of situations in which a child may be competent as a matter of fact. So, for example, has sufficient intelligence and understanding to, make a particular decision, but the courts have said that does not then give them the legal entitlement to make that decision. So the courts have increasingly recognised a clear distinction between a child having mental capacity or competence in an area and the legal capacity and competence to make a particular decision. And the first major example of that being analysed was by in the case of NHS Trust and X, which was an application which concerned a 15-year-old girl who suffers from sickle cell syndrome. She was a Jehovah's Witness, as was her mother, and there was resistance to her receiving blood transfusions. And clinicians were seeking a rolling order to seeking the ability to give her those transfusions as required over a 2-year period. The argument that the young adult was raising there was that Gillick competent minors, which she was, age 15, she felt, they should be afforded the exclusive right to decide on their own medical care in the same way as their peers aged 18 or over. So she was essentially saying, you have to respect me as though I were an adult. Mr. Justice Mumby in the High Court said no. What he did was a very useful survey of the law, which recognised that in certain medical contexts, the decision of a Gillick competent child will be determinative. And he looked particularly at a case where a Gillick competent 13-year-old girl was held to have the right to decide for herself whether or not to have an abortion. And that's also the case in some non-medical contexts, so that the decision of a child who is factually Gillick competent, not objectively foolish or irrational, will also be determinative. Gave some examples, including, restrictions on publication, for example. But what he then came to decide was that was not the case for every single decision relating to medical treatment. So what needs to be done is, if a child is under 16, it needs to be, the right test for whether they're factually competent is Gillick. We need to look at whether they are of sufficient intelligence and understanding. That's correct. And if they are Gillick competent, then all well and good. And by operation of Section 8 of the Family Law Reform Act, that Gillick competence is given legal effect. So, as I've said there, Section 8 essentially deems the age of majority to be 16 rather than 18. But it doesn't do more than that. And what he was essentially saying is, if a child is then under 16 and needs to make a decision, just because they are Gillick competent is not the end of the matter. So in that sense, is rowing back the scope of Gillick to being the determinative test of whether a child has mental competence, but not the test for, in every case, for whether or not the child then has the legal entitlement, to the exclusion of all others, to make a particular decision. And this case was appealed to the Court of Appeal, and the Court of Appeal reaffirmed this in refusing permission to appeal. It says it's well established that the court itself may countermand the decision of mature minors in their best interests, and they are not conferred upon an absolute right to refuse treatment. So, in layperson's terms, what this means is, whilst Gillick is the right test to apply factually to assess whether or not a child is of sufficient maturity or understanding, Gillick is not always the answer to whether or not you can then use that child's agreement to make a particular decision. And in a recent Court of Appeal judgment, Mr. Justice McFarlane said essentially the same thing in a different context. Now, this concerned, as you can see from its title, an application in a very different context concerning a child's removal to Ghana in the context of a wardship of court order. So we're operating at this point within Section 1 of the Children Act, which is the Welfare Evaluation Best Interest Framework. And it was suggested before the Court of Appeal that because the wishes and feelings of the child concerned in this particular case were very strong, and this child was Gillick competent, that should almost be given determinative weight in the court's analysis. And Lord Justice McFarlane said quite clearly, no. And he confined Gillick to its own facts, to the ability of a young person to give autonomous, valid consent to medical treatment in that context. And he recognised that Gillick's now been used more widely, but what he was very clear about is that simply because a child, in this case a child called S, was Gillick competent, that did not give him or her the legal ability to determine the decision-making in their own case. And in this case, the wishes and feelings of that particular child were a factor to be taken into account under Section 1, but they were not the determinative factor. And so again, outside the context of Gillick, we can see that it is being constrained and restrained within, more and more to within its own facts and within a very specific medical context. So always important to be alive to that simply because a child is Gillick competent by way of, factual analysis doesn't mean that they are fully entitled to make their own decisions. Now, moving on then to a further complication is, since Gillick, there's also been a number of cases questioning, well, what does Gillick mean? What does the test consist of? And you will have seen that the GMC has taken a particular stance on this, and it has essentially adopted some of the functional test aspects of the Mental Capacity Act, So your need to understand, retain, use and weigh and communicate the decision, and adapted it to a child-specific context. This is exactly what Mr. Justice Cobb has also done in a High Court case from 2017. And what he has done is essentially said that what is required of a child to be Gillick competent within the scope of Gillick is that they must first understand the nature and implications of the decision and the process of implementing that, understand the implications of not pursuing that decision, retain the information long enough for the decision-making process to take place. They must be of sufficient intelligence and maturity to weigh up the information and arrive at a decision. So you can see there, it's the adaptation that's been required, because we're not talking about an impairment of the mind or brain as we would with someone over 16. We're talking about a child being of sufficient intelligence and maturity, and then it also requires them to be able to communicate that decision. This is a similar approach to that which has been taken in the Mental Capacity Act Code of Practice. But question then we have as lawyers is, well, what's the future of Gillick in light of these uncertainties, in light of the judicial examination of it, indicating that it needs perhaps to be revisited and analysed in more detail? So there are 3 points we wanted to highlight here, which are future developments which we are keeping a very close eye on. The first is the Mental Health Bill, which is currently in a ping-pong between House of Commons and House of Lords. And in the debates, the matter of the Gillick test featured quite significantly. The House of Lords wanting to put in amendments suggesting that Gillick competence should be put on a statutory footing, and the government expressing concern that this would be unhelpful, and introducing a test specifically for the mental health setting would create confusion and uncertainty elsewhere. You may think there already is confusion and uncertainty, but there we are. At the moment, it doesn't look likely that that will be the way in which Gillick ever achieves a statutory definition or a statutory footing. That being said, the Law Commission in September published detailed proposals for disabled children's social care, and they again have proposed very clearly that following consultation, that they have found that the view of the overwhelming number of practitioners and those who responded to the consultation was that Gillick should be put on a statutory footing, and that Gillick should be analysed through the lens of the functional elements of the test for capacity. So coming back to that Cobb analysis of looking at whether the child can understand the relevant information, can retain the relevant information, can use and weigh that information, and can communicate that information as the way in which Gillick competence for disabled children should be analysed. If that's enacted, obviously it might mean a dissonance between the way in which Gillick is looked at in the context of the Mental Health Bill and in the context of disabled children, but we have to watch this space. And finally, we are now also aware that we may be getting a new Mental Capacity Act Code of Practice next year. Perhaps this is another opportunity to clarify and refine the concept and its applicability. Who knows? Now handing over to Flora.
Thank you. So we're now going to look in a bit more detail at parental responsibility specifically, which is obviously a concept that was introduced and talked about earlier in this presentation when we were looking at the decision in Gillick. So parental responsibility is a term that you will hear thrown around a lot, probably. So we thought it's helpful to start by looking at what is it? And a little unhelpfully, it's a common law concept, and it's more defined by the limits of what it does and doesn't allow someone to do than it is clearly what it is in itself. So the best definition we have is from Section 3 of the Children Act, which you will see set out here on the slide. So parental responsibility talks about the duties, rights, powers and responsibilities and authority which by law the parent of a child has in relation to the child and his property. And for our purposes in relation to medical treatment, that's expanded upon in the judgment that we've set out a little extract from there in Re Z, where we're talking about giving consent to medical treatment of a child being a clear incident of parental responsibility arising from the duty of a parent to protect the child. So what that's just confirming is that making decisions about medical treatment is something that very clearly comes within those rights and responsibilities, duties and powers that are set out in Section 3 of the Children Act. Which leads us on nicely to our next slide, please. So what we want to look at now is, having sort of established what PR is, what does it mean you can do and you can't do. So as we said before, PR is most often defined by the sort of limits of where it exists. And there's a few particular things we want to pick out in particular here. The first comes from a Supreme Court judgment a few years ago in the case of Reed D, which I need to give Anita a shout out for. It was a case where she appeared in the Supreme Court for that case, so one we know very well. And what Reed D looked at was about whether someone with parental responsibility can consent to the confinement, so generally we're talking about deprivation of liberty, of a young person over 16. So for 16 and 17-year-olds, can someone with parental responsibility consent to that confinement on their behalf? And the Supreme Court was very clear that the answer to that is no, which creates a relatively complicated situation, particularly when we're dealing with young people who lack capacity. So obviously for over 16s, we're dealing with the framework of the Mental Capacity Act, but you might have a 16 or a 17-year-old who's in hospital. They may lack capacity to make decisions about their medical treatment. But if there are confinements or deprivations of liberty associated with providing that treatment, for example, if they need sedation or restraint to facilitate medical treatment, that is not something that someone with parental responsibility can consent to, even though they can consent to the treatment itself. And that's a really key distinction, often something that we see as an area of complexity for people who are working with children and young people. And so that confinement needs to be consented to by the court. It needs to be approved by the court, because there is no one else who can do that, because the young person cannot do it and those with parental responsibility cannot do it. One, I think, point we wanted to clarify as well in particular is about looking at best interests and whether there is this sort of synergy, if you like, between parental responsibility and best interests. And something that is very clear from court decisions is that it is not a requirement of parental responsibility that decisions are made in the child's best interests. It's something that, we would hope happens most commonly, but something the judge acknowledged in the case we've highlighted there, which is an NHS trust and the mother, is that, those exercising parental responsibility will sometimes make decisions which are not in a child's best interests. It happens every day in day-to-day life. For example, when parents need to balance the needs of the family versus the needs of an individual child. But where the role of the state comes in, and that's obviously what we do a lot of here, is where those acting with parental responsibility are considered to not be acting in the child's best interests, and the consequence of that decision is something that can put the child at risk of harm. And that is where, for example, the medical treatment cases that we often work on come into play. So looking at who has parental responsibility, which is a fairly complicated question for something that seems quite straightforward. So we're going to whiz through, hopefully, some sort of overviews and hopefully provide a bit of clarity here. So to start with a favored phrase, which is that not all parents have parental responsibility and not all people with parental responsibility are parents. Obviously, in the vast majority of situations, those two things are the same. But I think what we're trying to get at with that distinction is that those who fulfill the social role of being a parent to a child, so someone they would call their parent, who fulfills all of those things that you would expect of that relationship, could also be someone who doesn't have parental responsibility. And if you are someone who is responsible for seeking consent to medical treatment for a child or young person, when you are relying on parental responsibility, it is really clear, it's really important that you are clear about whether the person you are seeking that from is someone who has the legal ability to give it. So the first example is about the gestational mother. And I use the term gestational very specifically because parental responsibility is automatically bestowed upon the woman who gives birth to the child. And obviously with the development of reproductive technologies like surrogacy, that is not always the same thing as being the biological parent of the child. So we use the term gestational intentionally there. For fathers, if they are married to the woman who gives birth to the child, or if they are registered on the birth certificate, they automatically have parental responsibility. They may still have parental responsibility even if they are not the biological father. For example, if they are registered on the if they are married to the mother, as we say, at the point in time the baby is born. And a notable addition here is that if the father is if someone is the biological father, they automatically gain PR if they later marry the mother who gave birth to the baby. So a few other situations that it's worth being appraised of. So a second female parent, so for same-sex female couples, can be registered on the birth certificate if both mothers register the birth jointly. And then there's a wide range of scenarios in which a court can make an order that bestows parental responsibility on someone. And so some examples of that might be after surrogacy. So we have Section 54 of the Human Fertilization and Embryology Act, about the scenarios in which you get a parental order. So becoming the legal parents of a baby that was born by surrogacy, because obviously, as we said, where we're looking at gestation as the marker of parental responsibility, the surrogate would hold parental responsibility at the point the baby is born. So there are orders providing for that. Also, for example, something that quite commonly comes up is where you have child arrangements orders. So something called a special guardianship order, which is something you may have come across in practice. So these often reflect the scenario where it's a legal recording of the arrangements already in place for a child or are going to be put in place. So often called a lives with order. So where a child lives with someone and that's recorded to document that in the court order and give them that legal status, that also bestows parental responsibility as a side effect of that. And finally, another key example as well is about local authorities. So where a child is subject to an interim care order or a care order, that also bestows parental responsibility on the local authorities. So they have a legal right to make decisions about what happens to that child. So it's worth being alive to these kind of scenarios where you have these kind of more complex situations and how that can impact parental responsibility, and so who needs to be consulted on these decisions. And finally, something just to pick up on about removal of PR. This one is a little bit more simple. PR can only be removed by a court order, except for, and it can only be given in the specific circumstances above. So no one can take away PR apart from a court. This is a fairly hot topic of conversation at the moment. You may have seen things in the news that the government are looking at options for having a system whereby parental responsibility is removed from a parent convicted of serious sexual offences. So it may be there's more developments on this in the future. But for now, if someone is saying that parental responsibility has been removed, you would need a court order to evidence that. So we're now going to look at some specific treatment decisions. So the kind of areas which you want to be alive to for where there might be particular complexity around parental consent and areas where we commonly see issues coming up. And the first thing we want to touch upon is about treatment for gender dysphoria in children and young people. So as many of you may have seen, a few years ago, there was some very high profile litigation in the Bell and Tavistock case, which some of our colleagues did work on. So what that was looking at is whether there should be a different test, essentially, a different application of Gillick for children and young people who are making decisions about treatment for gender dysphoria. So specifically puberty blockers, cross-sex hormones, and whether, because the court was looking at the idea of whether, gender is something that's so integral to someone's identity that there should be a different way of assessing competence for that. The High Court did find in favour of the applicants initially in that case. So they were looking at a stricter test where there was also more clear delineation between different age groups. So almost setting up a framework within Gillick saying, well, children at X and Y age may not be able to do this, but this specific age they may be. So almost creating categories within that, which, as you will see, is very different to the approach that came from Gillick originally, as Anita highlighted earlier, where a key factor of the Gillick test is that not all children are treated the same and there is no blanket approach. And the Bell decision originally was looking at putting some more sort of universal guidance on age ranges for Gillick competency in that context. That was overturned on appeal by the Court of Appeal. So now the position is that decisions for treatment for gender dysphoria are not treated any differently to any other medical treatment decision in terms of the way that consent is structured for that. So the requirements of Gillick competency and parental consent and how those things intersect. But again, because it is such a sensitive area, it is likely to be a high bar for competency, which, as we said, is always going to be time and decision specific for a child or young person. Another area we've recently had some useful guidance from the court upon is about the treatment of eating disorders in children and young people, specifically NG feeding for anorexia. So there was a case last year, which we referenced a little earlier as well, about an NHS trust. And this was about whether you can rely on parental consent to restrain a child for NG feeding where their child is not able to make that decision for themselves, and it's a child who's under 16. It's worth just flagging this is specifically in a context where the child was not able to be detained under the Mental Health Act. And so you're looking at then a parental consent framework. And what the judge was very clear in that case is that the parents can authorize that restraint. So for an under 16-year-old, if restraint is required to facilitate NG feeding, that is something the parent is able to consent to legally. It's obviously, again, a complex and sensitive area, so it's one where it's going to be a case-specific consideration. And, if you're looking at an increasingly significant level of restraint, that might be one where you want to get some advice and look at how that is being managed, just to make sure that you're comfortable that that restraint is within those remits.
Thanks, Flora. So moving then to the third example on the sheet, concerning non-therapeutic sterilization. And this is a particular special case, and historically, the only case in which the court has found there is a legal requirement to come to court in respect of the treatment of a child, even if both parents are consenting to that treatment. And that was the decision of Mrs. Justice Halbrun in Reedy as early as 1976, which concerned the non-therapeutic sterilization of an 11-year-old. And the principle that it should be brought to court was reaffirmed in an adult's case in 2013 by Mr. Justice Cobb. This application concerned a patient who was 21 years old, suffered from Down syndrome and associated learning difficulties. Their parents became increasingly concerned about the risks of them engaging in sexual activity and the potential detrimental impact to her well-being should she become pregnant in the future. The parents formed the view it would be in her best interest to undergo sterilization procedure, but Mr. Justice Cobb was very clear that this was one of the categories of cases which should be coming to court. And at that stage, he relied upon the practice direction 9E, which, as we know, has all been withdrawn, but nonetheless, its principles remain applicable because the court was very clear that the decision as to whether someone who lacks capacity should have a non-therapeutic sterilization was one, firstly, involving serious medical treatment, but also where the guidance specifically said that that was the type of case which should be brought to the court. And one would think that where the decision is being taken in relation to not an adult but to a child, the gravity of the decision would be in fact even more serious. And so this has to be, I think, on everyone's radars as a case that in every case needs to go to court, regardless of disagreement or a lack thereof. And finally, in relation to withdrawal of treatment, we have a number of inquiries as to whether or not withdrawal of treatment is something that always requires a court application. And in some senses, it makes sense as to why, because in a sense, that's one of the most serious things that you can do. However, there has been conclusive Supreme Court guidance on this, which confirms in the decision of Re-Y in 2018 that parents can consent to the withdrawal of treatment in relation to their child. The key point is that there needs to be agreement between all those individuals concerned with the welfare of that individual, and that the decision, as I say, needs to be taken by everyone acting in concert. And if that is the case, a court application doesn't need to be made. And obviously, if we fall short of that, then it would be it really depends on the nature of the dispute. So always best to, if there is disagreement, seek legal advice. But if you are genuinely satisfied that there is full and fulsome consent from everyone and agreement to the proposal, then that can be done without a court order.
So that follows on nicely from that in terms to look at some specific problem areas about capacity and consent. So we've talked about some specific treatment areas, and these are sort of more general issues where we often see problems cropping up. And starting with looking at disagreement, which obviously is something Anita has just touched upon in relation to withdrawal of treatment. But more generally, a question we get a lot is about whether you need the consent of, as usually will be the case, both people with parental responsibility for treatment, or is one consent enough? And what happens when someone disagrees? So the legal position is that the consent of one person with parental responsibility is sufficient basis to proceed with treatment. But I think what's really important here is to note that what we're looking for is not necessarily positive consent from both people with parental responsibility or all those with parental responsibility, but what you really need to be alive to is dissent. So if you have any indication that someone with parental responsibility has objections to a proposed treatment even if you have the consent of someone else with parental responsibility, that's an area where you would be wanting to get some advice and have a look at that. Because where you have a disagreement, where there is a substantial disagreement about proceeding with treatment, and that can be where there's a disagreement where one parent consents, one parent objects, that is when the court would need to become involved and make a decision on whether the proposed treatment is in the child's best interests. Another commonly raised query is about the refusal of treatment by a Gillick competent child. And this is an area that has been under discussion a lot in recent years and has sort of progressed over the years. So the current position is that parents cannot trump the decision of a Gillick competent child. So you can rely on parental responsibility if a child who is Gillick competent, for example, refuses to make a decision, but you cannot rely on parental consent to overrule the refusal of a Gillick competent child. So historically, there was more of a mixed view on that, but in the more recent decision of A, B, and CD, which we've referenced there, the court was very clear that you need to, that would be a decision for the court. So the court can overrule the refusal of a Gillick competent child, but it would not be appropriate to rely on parental consent in those circumstances. So if you're getting those kind of differing views, again, that's something where it would be very advisable to seek legal advice. And then just briefly on these other 2 points about the sort of boundaries of parental responsibility, as we touched on earlier about the sort of limits of PR, you don't have to be making decisions in best interest. That is not a limit that is put on parental responsibility, but obviously that is where intervention often comes if there is concern about how it's being exercised. And then also in terms of what you can't do with parental responsibility, highlighting again this point about you cannot consent to confinement of a child or young person who is 16 or 17. So if there's a deprivation of liberty, that is something that court authorization is needed for, because a parent cannot consent to that on their behalf. And again, often these are, really at the edges of where we have legal guidance, and often, practitioners are really operating towards the sort of grey area. So, for example, if you have an under 16-year-old who's subject to an extremely high level of restriction, there may be a question about whether clinicians are comfortable relying on parental consent for that, or whether you want to be looking for court authorization. So again, that's something where if it's a very complex and nuanced situation, you should probably be looking to get some advice on that. And then finally, delegation of parental responsibility, I think is often something that often comes up a lot in practice. Consent to medical treatment decisions cannot be delegated. So you can't have a situation where, for example, mum sends auntie to come to the appointment with the child and says, auntie can consent to whatever intervention is being proposed that day. I'm happy for auntie to do that on my behalf. Unfortunately, that is not sufficient. You cannot rely on that. So in those kind of scenarios, it's worth thinking about what other ways can you take consent. For example, it's advisable to have a policy about telephone consent and how that can happen, because it needs to come from someone with parental responsibility. That is not something they are able to delegate. Obviously, if you end up in a situation where you do not have access to someone who has parental responsibility, for example, parents are unreachable, uncontactable, if there isn't anybody who has parental responsibility that you're aware of, then that is when you need to be seeking urgent legal advice, and court involvement would be indicated.
So picking up then where Flora left off, genuine emergencies, how do you take decisions? And I think the first point to highlight is, as she indicates, we don't need the person there in person. If the person holding parental responsibility is accessible over the phone, is able to make a decision, via email, then that is what should be done. If it is not a, true emergency. If it is a true emergency, and you have time, then again, a court application may well be the appropriate way forward, but it's very fact dependent. But then we get the situations where it's an actual emergency, and if you don't intervene, then the child's at a life-threatening risk. And at that point, where treatment is vital and waiting for parental consent would place that child's life at risk, treatment can proceed without parental consent on the basis of essentially the common law, that it's necessary to act to safeguard the child's life. But those are very limited circumstances, they're ill-defined, and are really genuinely only to be used in the case of an actual emergency. And we do deal with cases like that, they do arise, but it's important to be clear, not all emergencies are equal. Now then, we've touched upon the point below that, which is what is the standard for assessing competence if it's not Gillick? How should competence be assessed? At the moment, the approach of your regulators is probably the best approach to be taking. The approach advocated in the codes of practice. That is the best I think we can do at the moment, absent a statutory definition of how Gillick competence should be assessed. It's not even clear that that's going to be enacted. So this very much is an evolving area of law where we are keeping a close eye on these developments. But at the moment, in terms of a factual assessment of Gillick competence, the test remains sufficient maturity and understanding. And as we have already discussed, whether or not that means that the child's decision is determinative depends on the facts of the case. And just to add to everyone's complexities in this area, we wonder if there's now also another question as to what constitutes valid consent. The Supreme Court last month heard a case which was a reference from the Northern Ireland Attorney General, who was looking to give legal status to the consent of individuals who have been found to lack capacity within the meaning of the Mental Capacity Act, and was asking the Supreme Court, can we do that? Is that lawful? The Supreme Court has reserved judgment, as you would expect, and the decision is likely to come down early next year, we understand around May. But if the court says that approach is lawful, it starts to open doors to whether or not holders of parental responsibility who lack capacity, but who have assented to a particular course of treatment for their child, that could be sufficient for the treatment of the child. Right now it is not, but it could be. And the other area that it may open up is children over 16 who already fall within the framework of the Mental Capacity Act, but if they lack capacity under that act but are still assenting to treatment, then on behalf of themselves or their own young children, what then? So there are a number of questions that decision will raise. If it affirms the current law, they will only have the current problems. But if it changes the law, then obviously watch this space, and we are, as are we, with keen interest. So thank you very much for listening to our whistle-stop tour of this extremely complex and evolving area of law. Somehow we finished relatively on time, which I'm happy about, and unexpectedly so. So I wanted to open the floor to you all to ask any questions. Obviously, we can't give any specific legal advice on cases, but it would be great to have a discussion with you all on this complex area.
As the general principle, as we said, so the specific ways that parental responsibility is bestowed upon a father would be birth certificate or married to the mother at the time the child is born. So assuming that father is not on the birth certificate, as it looks like, and is not married to the mother, then the position would almost certainly be that they do not have parental responsibility. So yes, if you're looking at consent to medical treatment decisions, for example, they could not provide valid consent no matter how involved they are in the child's life. I think this is a prime example of why we have the expression I used earlier about how not all parents are people with parental responsibility. This is a great example of where that can be the case. So obviously we can't provide any sort of specific advice, but yes, generally then it would be the onus on the individual to get advice about what their options are for obtaining parental responsibility, and there are processes in the family court to do that. And yes, you're right in saying that any decisions that need to be made would need to be made by someone known to have parental responsibility. So here the biological mother, assuming that is also the gestational mother.
Why don't we both take this? Yeah. Unfortunately, I think the answer is it depends, because if the treatment is something that is quite significant, then I think you would be feeling increasingly uncomfortable in the context of that disagreement, because the default position is, yes, whilst you do need one consent, in the event of disagreement, as Flora has outlined, you should be thinking about going to court. But say, for example, there is a way to get the parents, in a room together with the clinicians to explain the risks, explain the benefits, disbenefits, and help them reach a really informed decision, allay their anxieties, then that would be better for everyone. And I think I wouldn't immediately be jumping to go to court if you had that option. But ultimately, if this treatment is threatening the life of that child, then, or not providing this treatment is threatening the life of that child, then yes, you would be thinking about, as a trust, going to make a court application. You could rely on the disagreeing parent, but the difficulty is the trust still owes a duty of care to the child and to provide safe and effective care to that child. And if the parent's lack of consent is threatening that, then we should be the ones taking it to court.
I think something I would just add to that as well is that I think often, particularly in scenarios where you have two parents and one parent agrees, one disagrees, we very often see cases about how perhaps conflict between in that parental relationship is almost spilling over to medical treatment decisions impacting a child or young person. I think it's very easy to frame that as a dispute between the parents, but it is still a dispute between the organisation and a parent, even if you have one agreeing, one not agreeing. It's not isolated to that relationship. So I think where, obviously it's case specific, but I think as a general rule, if you have someone actively disagreeing with the treatment that you are providing or wanting to provide, then that is something probably that you would be wanting to look to escalate. In terms of continuing the treatment, it's going to depend a lot on what the treatment is, what the necessity of that is, the risks of stopping, those sorts of things. But if it's something that's being provided on an ongoing basis, then that is probably something you would be wanting to look at getting input for.
Well, I think it comes down to the heart of Gillick, isn't it? It's about the child having sufficient maturity and understanding to make the relevant decision. And, as a rule of thumb, if you look at what the relevant information the child needs to know is, if you look at whether they understand that, check they understand that, check that they can retain that information, check they can use and weigh that information, and check that they can communicate a decision to you, that framework is likely to be the best way of comprehensively accounting for why you believe the child has sufficient maturity and understanding. Age alone is obviously insufficient, as Gillick says. I think the difficulty that you have there is more a practical one rather than a legal one, because I think if the person is refusing to engage, the question is why. Especially if the person's 16 to 17, there's a presumption of capacity, and we shouldn't be conducting assessments on people who have capacity who don't want them. But so in that sense, I think a parent couldn't consent where the child is within the MCA framework. But if you had a child, say, under 16, who is just not engaging and doesn't want to speak to you, I think legally you could probably, if it's just an assessment, and that's not, suggesting any interventionist approaches, but just simply speaking to the child, then I think your parent could consent. But what's the point? Because the child's not engaging. I think, as I say, then I think for children under 16, it's more of a practical problem than a legal one.
So the short answer is yes.
Yeah.
So if you're on the birth certificate, you have parental responsibility. That is something that can only be removed by court order. And again, this is, I think, why it's really key to bear in mind that distinction between parental responsibility is not a reflection necessarily of the actual realities of that child's life. It's a legal status. I can actually see in the chat, and I'm just going to take this one very quickly as well, a question about whether a female non-gestational married mother has parental responsibility or only once birth certificate is done, because it's a similar question. I am a little bit unclear from the question whether you are referring to a same-sex relationship where it might be a second female parent or a surrogacy case. So obviously it will be case specific. If it is a second female parent in a same-sex relationship, if they both register the birth, they can both be put on the birth certificate. If it is a surrogacy case where it is the biological mother but who is not the gestational mother, there is a court process for that, where the intended parents essentially have to obtain parental responsibility via a court order. So that's a very quick answer to those questions.
Yeah, if we haven't quite got the gist of what you were getting at, do just drop us a line.
Yeah.
I think the first thing to say is a school can't hold parental responsibility for a child. I don't think they're always legal bodies either. But I think the other point is, it would be, I think if the author gets in touch with us and explains it in a bit more detail, it might be more useful, because at the moment, I'm not sure a school could override health. I mean, but in the case of, for example, children's vaccinations, the way that it's done is they, as you probably a lot of you know, they email out all the parents, and all the parents who said yes to the vaccinations have their children vaccinated at school, and all the parents who said no to the vaccination don't have their children vaccinated at school. That's how it works. And so it's not about delegation of PR, it's about seeking the decision of the holder of PR, which the school then executes, but it's executing a decision of a holder of PR. It's not sort of acting in loco parentis per se in that context. I think the short answer is yes, but it's probably beyond the scope of what we can talk about today, because it really is situation dependent. I think it's something that we can pick up perhaps in a future webinar, but also I think, you know, you've got to look at whether or not you're looking under the MCA, you might be looking under the Children Act, you might be looking under the MHA. There's a variety of options.
So this is actually a really good point to raise about how information sharing, again, is going to be something that you're looking at the child's competency for. I'm specifically not using the term Gillick competency because of what Anita talked about earlier from the recent judgment for the wardship removal to Ghana case, because Gillick is not applicable here, but you are still looking at competency essentially. So you would need to assess the competency of that child to consent to information sharing. That is what this is about. If they are assessed to be competent to decline information sharing, that includes with their parents, then those wishes need to be followed. I think this is a one that really comes to practicalities as well. So what steps can you take to try and make sure that, try and help persuade the child or young person that, you know, their parents should be involved? If there's concerns that maybe fall into the safeguarding arena, do the local authority need to be involved here? So that's probably a situation where there's a lot of practical concerns as well. But if the child is competent and refuses you contacting their parents, that needs to be respected.
I mean, I'm not personally aware of it, but I must confess I haven't looked. So I think certainly my own experience is it's opt-in, but we'd be happy to kind of take a look and then get in touch if that's helpful.
That's going to be a case-specific scenario. So as a very general principle, if there's an SGO, I probably would expect that there are still other people with parental responsibility, but it's going to be very case specific. If they were the birth mother, then, you know, there might, if there are other court proceedings, you know, it's going to be complicated. But generally, I would probably anticipate there are more people than just the person with the SGO who holds PR, but that is something that would need to be looked at as a case specific.
Yeah, and just to add on to that, there is then another question as to why the SGO is in place. And for example, is it because there's a history of not of the individuals like the birth mother, etc., not acting in the child's best interests in the past? Generally, there aren't SGOs absent care proceedings in my experience. So in which case, it's also worth looking at, okay, well, who should we actually be talking to? Who's the person who is actually taking day-to-day care of the child? Because when you have a range of PR holders, you need to be looking for the person who is, you know, involved essentially. And if the person who has been exercising PR previously and who may still hold it is not taking decisions in the child's best interests, probably not the person whose consent you necessarily want to be relying on, even if you could. I mean, all other things being equal, probably. I think it depends, because if they are Gillick, competent in the sufficient maturity and understanding sense to take that decision, and the health screening questionnaire falls within, you know, the scope of the sorts of health interventions that Gillick applies to, then yes. But I think it would really depend on the purpose and what it's about. I am not sure, but I imagine they probably do anyway. You know, we can have a look into that.
Yeah, I think it's probably a scenario where it's going to depend on how old is the child competent, is that something they can make decisions about? There's probably like a general yes, but then it will depend a lot on the scenario of the case. So like, what is the dynamic? Are there concerns? Obviously, when we're getting into subject access requests, information sharing, there's a whole separate set of things to look out in terms of harm thresholds, all this sort of thing. So it would need specific consideration of the nature of that relationship and that dynamic.
I mean, I think if the patient lacks capacity, we're already talking about an over 16 rather than an under 16. And in which case, if they lack capacity, a parental consent is not a valid framework for consent to that intervention in any event. That's the first thing to say. Second thing to say is if we're talking about a child under 16 and competence, then I think you have to really ask yourself, is this a genuine emergency? Because at the end of the day, we can't, our advice, we're just giving general principles. We can't give advice on specific legal situations until we know what the facts are. And if it's not life-threatening, I would be very reluctant to be, looking to do that. It may be that there is some less restrictive measure that could be put in place. So, for example, you could give them a local anaesthetic to stop their tooth hurting as badly whilst you contact the parent to see what else can be done. But it really is case by case.
I think this is one where, unfortunately, we would need more information to be able to comment. So, what kind of decisions are we talking about? Parental responsibility is connected to the child. So, if a child very sadly dies, the legal status of that relationship is obviously different, where the child, is no longer alive. So yeah, if there's a specific question there, obviously please do get in touch if you're able to provide a bit more information about what the decision in question is, what the kind of issue that the teams are facing are, because I think unfortunately we probably can't say any more just from what we have there.
And I'm just conscious it's now also 2 o'clock for everyone. So please enjoy your afternoons, and we will, if helpful, take your questions by email. And otherwise, I hope you've enjoyed it. I hope everyone has a lovely afternoon.